Welcome everyone. Welcome to the Arizona Law Faculty Book Talk Series. It's great to see everyone here today. Today's event is co-sponsored by the Daniel F. Cracchiolo Law Library and the College of Law Clerkship Committee. I am Marcelo Rodriguez. I am the Foreign Comparative and International Law Librarian. I am also a professor of legal research, but today I'm actually here also in my capacity as a member of the Clerkship Committee. And I just want to make sure that, especially for the students here in the audience, that you know that we are a committee of 5 faculty members, and also Caitlin here for the career office. We're here to help you navigate what does it mean to apply for clerkships, and the book will be perfect in that topic. Just be inspired by the conversations and then come talk to me, come talk to Caitlin. We're here to help you, okay? This afternoon's book talk features Professor Tessa Dysart in conversation with Dean Marc Miller. They will be discussing Professor Dysart's new book, A Short and Happy Guide to Judicial Clerkship. And I'm happy to say that we have copies, print copies, as well as virtual copies online if you're interested in checking them out. Okay, so now for the introduction. Professor Tessa Dysart is the Assistant Director of Legal Writing and Clinical Professor of Law. She also serves as the Editor-in-Chief of the Journal of Appellate Practice and Process, which was acquired by the University of Arizona Law in June 2020. Professor Dysart writes and speaks nationally on appellate advocacy issues. She co-authored the 3rd edition of Winning on Appeal, Better Briefs and Oral Arguments. She manages the Appellate Advocacy blog, which was added to the ABA's list of best law blogs in 2018. Professor Dysart has also written on human trafficking and constitutional law and lectured nationally on developing effective state anti-trafficking laws. Professor Dysart's practice experience includes working for the United States Department of Justice Office of Legal Policy and the Senate Judiciary Committee. Prior to joining the College of Law faculty, she taught appellate advocacy and constitutional law courses at Regent University School of Law, where she coached award-winning moot court teams and advised the program to a national ranking. Immediately after law school, Professor Dysart clerked for the Honorable Dennis W. Shedd for the U.S. Court of Appeals for the 4th Circuit. And now, Marc Miller. Marc Miller is the Dean and Ralph W. Bilby Professor of Law. He joined the University of Arizona College of Law in 2005 after 7 years at Emory University Law School, where he also served as Associate Dean for Faculty and Scholarship. Dean Miller writes and teaches about environmental law and policy and criminal law and policy. He's the author of more than 70 articles and essays on a wide range of environmental, criminal justice, immigration, and legal theory topics. He is editor of several case books on criminal procedure and sentencing, and co-founded the Federal Sentencing Reporter, the leading journal on sentencing law and policy, in a joint project of the Vera Institute of Justice and the University of California Press. Before teaching, Dean Miller served as law clerks to Chief Judge John Godbold of the U.S. Court of Appeals for the 11th Circuit, as attorney advisor in the Office of Legal Counsel of the U.S. Department of Justice, and as special counsel at the Vera Institute of Justice in New York. Please join me in congratulating Professor Dysart on her new book and thanking her and Dean Miller for joining us today. Thank you.
So Tessa, you very evidently like to write and to edit, not only articles and a journal, but books, as the last few years have demonstrated. Why write this book?
Well, the short answer would be because there's a smiley face, and this is the only book my 4-year-old likes because of that. The long answer is I felt that there was a lot to be said on clerkship. So for my entire teaching career, I have been advising students on clerkship. And that advice is really refined in the last few years. And I thought, and it's actually inspired by Paul Bennett and his book talk on A Short and Happy Guide. I thought, I'm going to put this on paper. I'm going to take all this advice and put it down and make it more accessible for students. And the goal of the book is first to demystify law school. So growing up, I grew up in rural Southern Oregon. I think I knew one attorney When I got to law school, I was shocked at the number of people wearing colored shirts. Like, why would you voluntarily wear a colored shirt to class? I was shocked that you had to pay for bar review. I thought I was paying for law school to teach me to take the bar. And so there were so many things that were part of the secret menu. And I wanted this book to demystify the secret menu of clerkships. I also wanted students to know that the advice they may be getting, not here because we're better than that, but at other schools about clerkships really doesn't always identify all the possibilities out there for students. And so I wanted students to understand that there is potentially a clerkship out there for every law student, not just the students at the top of the class.
So let's talk about that, because that's one of the major themes of the book, is the incredible rich array of clerkship opportunities for students who are interested. Why don't you talk some about not necessarily every court, because you discuss a lot of courts, but some of these broad opportunities and what the distinctive advantages they provide might be.
Sure. So let me start with why students may have a not complete view of clerkships. So 11% of law professors graduated from Harvard. And I mean, I'm in that group, but 11% of law professors graduated from Harvard. Harvard sends, of its 560 students each year, it sends about 110 students to federal appellate clerkships. So like a fifth of its class, if I can do math. And it sends 23 students to state Supreme Courts. Chicago, another school I could find statistics on, has 190 students in each class. It sends about a quarter of its class to federal appellate clerkships and 7 students to state courts. And there are way more state court clerkships out there than federal appellate clerkships. There's only about 190 active federal appellate court judges, and they each take 3 to 4 clerks. So if you look at the vast array of state court clerkships, which you can say a million times, and it could be a good tongue twister there, there's so many more opportunities out there for students. But even in the federal system, we have the federal appellate courts, we have the federal trial courts, federal district courts. There's more federal district court judges out there. Then we have magistrate judges. Who here has heard of a magistrate judge? Okay, they do a lot of the legwork for federal district court judges. And in fact, in civil matters, they can actually hear the whole case upon consent of the parties. So that's a great opportunity. Bankruptcy court judges. I learned actually in doing the book that many bankruptcy court judges didn't come from a bankruptcy court practice. And in fact, a bankruptcy court clerkship can be a very general clerkship for students. And then there's administrative courts. So if you come to my office and say, Professor Dysart, I really want to practice immigration law. I know that's what I want to do for my career. I'm going to say, go clerk in an immigration court. That's an administrative court. You will have an amazing opportunity. You will learn so much on the ground work, far more than the 1 or 2 immigration cases you may handle at a federal appellate court. So the federal system, there's military courts, there's tax courts, there's international trade courts. Then the state system parallel, you have the state appellate courts, the state trial courts, you may have state administrative courts. Then you have on top of that tribal courts, and Marcelo encouraged me to include international courts. So there's so many opportunities really for any type of practice, even transactional work. There's clerking at the Delaware Court of Chancery, which can be an amazing experience for students who are interested in transactional work.
So how does a student begin to explore these full range of opportunities, since it's not just the socialization of faculty? And again, you talk about socialization. My father clerked for a state Supreme Court justice in 1960. So I grew up thinking that's what you do when you graduate from law school. But apart from faculty socialization, there are established processes, not every judge follows them, for federal trial and appellate court clerkships. And there's typically established processes for state Supreme Courts, often for state courts of appeals. But this vast range of courts in the federal system, Article 1 and Article 3 courts, in the state system, how does a student or a law school begin to get their hands on that full range of opportunities? Does your book exhaustively cover that territory?
I mean, I can't say exhaustively because I'm sure I could be sued for that, right? Misrepresentation. It covers a lot of the information out there, but of course the information always changes. So there's a responsibility. Let me start with law schools. I think that there's a responsibility for law schools to know where their students like to go and clerk, right, just generally, and then have the relevant information about the judges that are the typical market for their students. So let's use Arizona, for example. We have a lot of students from Texas. You look at Nevada, there's only one law school in Nevada. There's only one law school in New Mexico. We send students to California, to Colorado, up the Pacific coast. So it's important for our career office to know of the opportunities in the Rocky Mountain West Coast region and Texas, which is its own special area, to be aware of how the magistrates are hired, to be aware of what judges follow the federal hiring plan, which we can talk about. So that's a responsibility of law school, and to be willing, if a student comes to their office and says, I really want to clerk for a magistrate judge, do you know how the magistrate judges hire in this particular jurisdiction? The office should be willing to make those phone calls if the student doesn't feel comfortable doing it. But there's also a responsibility on the student and the remainder of the law school. So students come into my office usually saying, Professor Dysart, I want to clerk. And then we start a conversation, right? Where, what do you want to do with your career? I don't know. All right, well, let's look at some general clerkships. Where do you want to be? Well, I think I want to go back to Oregon. Okay, well, let's talk about that. So students need to do some self-reflection on what they're looking for in their career, to the extent that they know as a 1L or 2L, which you don't always know. I mean, what I ended up doing in my career is different than what I think I thought I would do as a 1L. So faculty can advise students on that. And then students need to do some really careful research, looking into the judges, looking into the courts that are available, and making, I advocate in the book for a list. You have your list of judges that you're applying to, starting to carefully research those judges.
So as you've placed some burden on schools, they can certainly help students. I expect and hope schools would always be willing to do that. They can be proactive in thinking about where many of the students want to look, and so get information in advance. You've talked about the student responsibilities. You've left the courts off the hook. And again, if we're going to come back and talk about the federal system or the hiring guidance, why don't we do that later and think more about the clerkship experience? But I'm not sure we should leave this question yet of how can you match and how can you know? Because what you've painted is a very complex landscape. And it may be true that neither the school or the student is going to be able to know or easily find, or even not so easily find, questions about variation of judges within an administrative court or a specialty court. And so should courts do a better job? And can you give us an example of a court, one of these specialty courts, where you say, well, they have a clerkship page and that's where they put the information. And it's so clear. And if only every court would do that, what would that court be?
I think there's a couple of models for courts. So of course, courts should be transparent, and in a perfect world, they would be. The EPA and the Immigrations, the Environmental Protection Agency, the Department of Drug Enforcement, and the immigration courts, they all hire clerks for their administrative bodies, and they hire through the DOJ honors program. That's a very transparent program. You apply at the start of your 3L year, which I think is actually an ideal time because you've had your 2L summer to get a writing sample, to get letters of recommendation. So that's a very well organized system. Some of the administrative courts also have very good internship and clerkship pages if you do a little bit of poking around and searching, right? So you're watching whatever you watch on TV these days, and start searching administrative courts and find if they have a clerkship page. Some of the military courts actually have, under each judge, there'll be a link to that judge's hiring preference. So that's beneficial if judges have their own specific, what they're looking for in clerks that may differ by particular judge on a court. But I mean, certainly having a public, easy to find on the internet, same time every year, all the judges follow the plan. That is the ideal situation, but that's not the situation that we have.
All right, well, let's put a placeholder there and think about whether West might send a copy of your book with a letter to every chief or managing judge and say, here's a model, here's a resource that if students want to apply, here's a resource that members of the court might use. But let's put aside the court responsibility for a moment and think a little bit about the clerkship experience, which you talk about
Yeah.
at some length in the book. You open with the idea that everyone should clerk. I share that general leaning. But why?
Well, I can't give all the reasons because West would be really mad at me because then no one would buy the book. But I will give you a few reasons. So one of the reasons is I really, and maybe this was just me, but I would have been a terrible lawyer if I went to practice immediately after graduating from law school. I had no clue what was going on. That was probably actually a function of Harvard more than anything else. And so clerking, if anything, taught me what I don't know. I got exposure to all different types of cases. I gained confidence, right? I saw lots of oral arguments. They were all terrible. I was really excited. We had one case involving Microsoft, and I thought surely Microsoft can afford good attorneys. And that was maybe our best oral argument, but it still wasn't amazing. I learned how the court operated. So I actually got great insider information on not just my judge's decision-making process, but how other judges on the Fourth Circuit, worked. And that ended up being valuable. When I finished my clerkship, the Fourth Circuit would only post the morning of argument is when you found out what judges you were arguing in front of. That's not typical for federal circuits, but that's how the Fourth Circuit does it. So when I finished my clerkship, I would have friends arguing in front of the Fourth Circuit, and I would get calls at 8:30 in the morning. Tessa, they just posted my panel. What can you tell me about these three judges? And I would tell them everything I knew that, and then they would have an hour to prepare before their argument. So clerking gives you information about how to be a better attorney. I think if you clerk in a jurisdiction that you want to practice in, it exposes you to the court rules. You will know better than anyone else in your firm what the court rules are and how annoyed the judges are when they aren't followed. You'll know who the good attorneys are, right? You'll know the behaviors that annoy judges, that if you're in a trial court, can annoy juries. You'll know what they find persuasive. You may know the reputation of firms. So maybe you really wanted to go to XYZ firm, and then working in the courthouse, you find that that firm doesn't have a great reputation for being ethical and upstanding, and you decide you don't want to be connected to that sort of place. And then finally, you gain sort of a lifelong mentor and group of people who are on your side. So I have friends who have annual reunions with their judge, and they call their judge when they have questions about their career. The judge provides just an amazing wealth of information and advice over that judge's particular time in practice, and that's a huge asset to have on your side. Then you have your co-clerks who become your professional friends and colleagues, not just in your term, but in other terms. So I have co-clerks, one of them is a commissioner on the FCC, and I suppose if I did communication law, that would be amazing. And I enjoy seeing his social media posts about the work that he's doing. And then you gain friends of the people who clerked for other judges in your year. So 2 years ago, I think it was 2 years ago, I was sitting at my desk doing email, and I got an email from a Ninth Circuit judge, and he said, "Hey, Tessa, I'm going to be in Phoenix. Can I come down to Tucson and talk to your students?" Yes, you can. I would love for that to happen. And that's because we became friends when we clerked for different judges the same term. So that's kind of the fun, special, sort of tight-knit network that you get from clerking.
What about the skills? And here in your book, you talk at some length about the variation of clerkship experiences. So it's not one kind of experience, but can you talk about the kind? You were a clerk, you know a lot of clerks. What does a clerk do? What is it?
So it varies by court. I would say most courts you do a lot of reading and a lot of writing. So I know I have a reputation for perhaps being a difficult legal writing professor. Not as difficult as Professor Simon, but or maybe on par with her. And I know my class has this reputation for being really, really hard. So you could take my class and learn to be an amazing, even more amazing legal writer, because your first year professors do a great job on that. I would say a appellate clerkship at the federal or state level is on par with taking my class or a one-on-one writing seminar with Professor Simon, for all of those who've had her. So it is a very detailed look at legal writing, persuasive techniques. I think judges do persuasive writing. Not everyone would agree with me on that, but I think the work of a judge in writing opinions is, in essence, a form of persuasive writing. And so you certainly gain the writing and the research skills. I mean, part of your job as a clerk is to find out all the mistakes the attorneys made in their briefs. And then it's kind of cool when you do. You come to the judge and everyone's happy and the case gets kicked off the calendar and you go to lunch earlier, right? Because you have one less place for oral argument. So at the trial level, in federal court, you're still going to do some research and writing, but it's going to be much more time sensitive. You are going to be, the judge is considering a motion. It's on her desk to decide. You're trying to figure out the answer because you've got a 3-week trial going on, and that's the next step that has to happen in the process. So appellate court, clerkship, very little time in court, much more careful deliberation, sitting around talking about legal issues. It's like never leaving law school, right? Which is wonderful. That's why I'm still a professor. You're just talking and thinking about legal issues. Trial court, the federal level, much more time in the courtroom, dealing with parties and witnesses and attorneys. State trial court level, like you are just putting out fires 24/7, right? If you get time to eat your lunch, it's a good day. So you are dealing with the juries. You are really the only legal person, at least in Arizona and Pima County, that the judge has to help the judge do his or her work. So you are all the legal advice that the judge has to help. And that's, it's fun, but boy, it's a lot of work. If you want to be a prosecutor or a defender in a state trial court, like go clerk at Superior Court and you will learn everything you need to know.
So great attendance today, and I know you've been going around the country and getting a lot of interest at other law schools, and that reminds us that there are other law schools. For a current student, 1L, 2L, 3L, if they're following the traditional JD path, what should they be thinking about it? You said, when should clerkships be on their mental horizon? I assume the answer there is day one, start thinking about it. A lot of first-year professors, I think, mention and often give hypotheticals around clerkships. If you were a clerk for a judge, what would you do in the following circumstance? But if a student wants to begin to think about these courts, what should they be thinking about to build a strong, effective story? And then after discussing that, I want to turn to this critical concept in your book of fit.
Okay, so let me start with the 3 Ls. I think 3 Ls are potentially in the toughest place, right? You should have started thinking about clerkships earlier, from day one, or actually before day one, as I talk about in the book. But it's not too late for you. So you may not have known, but we just added 4 new judges to Division 2, 1 new judge coming in to replace a retiring judge, and 3 new open positions. And Division 1 up in Phoenix added 3 new judges. So there are 7 judges who need 2 clerks right now. So if you're a 3L, I mean, that's an amazing opportunity right there, that there's judges who need clerks in Arizona. In fact, when I was talking up in Oregon, I had a couple students who were interested in applying. So I try to save these spots for you all, but they're going fast. So 3Ls should be looking at new judges who are appointed or confirmed to state or federal benches. Sometimes, I tell a story in a book of a student who graduated from this law school. I think after graduation, he emailed me and said, so Professor Dysart, I was thinking about clerking and thinking, and you're emailing me after graduation, okay. And I'm looking at Superior Court. I said, I know you're a stronger student. You could do better than Superior Court, for your skill set. And I said, okay, well, let me see if I know of any judges who are hiring. We'll just hold on. That same day, another student who had graduated from here emailed me and said, Professor Dysart, I'm leaving my state appellate clerkship. Do you know anyone who wants to apply to this judge? And I said, as a matter of fact, I do. And let me connect to everybody. And within a week, the 3L got the clerkship. Okay, that is not typical. Like, please don't expect those results, but it's not too late for 3Ls to be looking at state court clerkships, even newly confirmed or appointed federal court judges. 2Ls, you're sort of in the heart of things, right? So hopefully you start thinking about this at the beginning of your 2L year. But under the federal hiring system, and the way at least a lot of state courts operate that mirror the federal hiring system, your applications are going to be due at the end of this semester. So right now, you need to be thinking about the materials you need for your application. What are those materials? Transcript, right? So focus on getting good grades this semester. cover letter. And I talk in the book about how those cover letters should be targeted to the judges you're applying to, not just a shotgun approach to apply to every judge with the same, very generic cover letter that doesn't explain why you, an Arizona student, wants to go clerk in Texas, when in fact you grew up in Texas and have longstanding ties to the state. And you're devastated that the Cowboys did so poorly in the playoffs this year, as they always do. And then your last, sorry, now I'm stuck on the playoffs. So your cover letter, your transcript, your resume, a writing sample. I advocate in the book that unless you are applying to the snobbiest of academics, who is now a judge, you should include a practical piece of legal writing. So something that you did in like my class, take an advanced writing class and write an appellate brief and submit that. Something that you may have done in an internship or an externship during your 2L year, but something that demonstrates the type of writing you would do for a judge, that's more practical. And then you should have letters of recommendation. Most judges want 3 letters of recommendation. And I tell the story in the book of when I was applying for clerkships. And so I thought my clerkship letters would be better if I went to the most famous professors at Harvard. So I went to one of my professors, who I won't name by name, and I said, "Oh, famous professor, my name is Tessa. I was in your class. Would you write me a clerkship letter of recommendation?" And he said, "Well, you didn't talk very much in class," which is probably like not at all in class, "and you got a mediocre grade." And I'm sure he said it nicer than that. He said, "So I would be happy to write you a letter, but that's what it would say." And then he gave me the best piece of advice was, "Why don't you find people who know you better to write you letters of recommendation?" And that was genius. So I went to some summer employers, my 1L small section professor, and I was able to get a really strong letters of recommendation that spoke to my skills. So I tell students, if you have a very famous Arizona law professor who knows you well, like go for that. But also go to professors like your writing professors who can talk about the skills that would make you a good clerk. So this is the time 2Ls you should be, cultivating those relationships with professors, approaching them about writing letters of recommendation, talking to them about why you want to clerk, that you want to clerk, so they can put the right information in your letter. 1Ls, you have a little bit of time, right? So I don't know if I think we have a handful of 1Ls in the room. So start thinking about it. Start thinking about where you might want to clerk. Start talking to your professors about the fact that you want to clerk. It helps us know when we get judges that email us and say, "I'm looking for some clerks," that I can say, "Oh, I had these 3 students talk to me about clerking, and one of them wants to go to Texas. So yes, Texas friend, here's a great student for you." Start thinking about classes that will be strong resume building classes. So administrative law, it's kind of scary. I mean, really scary, but it's a great class. Looks good on a resume. Writing classes. If you want to clerk in the federal system, take federal courts. That's very important. So, so as a 1L, you're going to get ready to register for classes pretty soon. Go talk with a couple of professors about your interest in clerking and classes that could help you achieve your clerkship goals.
Tessa, we talked about some of the themes in the book. Short book. It's not just the title, if you can see. It's a quick and good read, but some of these main themes, the vast range of opportunities, the understanding some of the both skill and long-term values in terms of building community, understanding the legal system better, succeeding as a young lawyer. All that's great. One of the other things we haven't touched on, but I mentioned with a word, but it's a word you use a number of times in the text, is fit. Can you help us understand fit? And that also goes to the letters you write and ultimately where you might end up, but it's such a central thing. Can you talk about it?
So there's so many aspects of the application process for clerkships that are important, but probably the most important aspect is fit, how you will fit into the judges' chambers, because you have to understand that it's such a small working environment. Judges don't often talk about how they would resolve cases with other judges on the court. In some courts, they don't do it at all until after oral argument, and some they might do it a little bit. So you, as the clerk, and the 1, 2, or 3 other people clerking for that judge, the judge's judicial assistant, who is the most important person in the judge's life, and the judge, that's it. That's the office. And so if you're not going to get along with everyone else in the office, it's going to be a miserable time for you and a miserable time with the judge, which means that when you get to the step of interviewing, the judge really isn't probably interviewing you to figure out your legal skills. Those are going to be demonstrated in your letters, in your transcript. You might have to do a writing test. Some judges are requiring that. The judge and the clerks, who you will also interview with, want to know if you're going to be a good person to work with. One of my friends who read the entire book and provided me some feedback on it, told me she lost a clerkship because she had never watched an episode of The Walking Dead. Right. So it seems crazy, right? That alone, and she's a very gifted student. But the truth of the matter is, if all the clerks are going to sit around and talk about The Walking Dead at lunch, she's not going to have a very good experience. They're not going to have a good experience, and it's just not a great fit. So when students come to me and say, I interviewed and I didn't get this clerkship, I commiserate with them, but fundamentally, it probably means it wasn't a good situation for that student and for that court. This is why researching judges and any connections you might have with a judge is so important. I spent a lot of time in the book talking about potential connections. You might say, I don't know any judges, and that's fine. That's not always the connections that we're looking for, but maybe you both are avid hikers, right? Or maybe you both play the specific, water polo in college, or maybe you both love dogs, or, some other connection that if you can find that makes you stand out to that judge. And, my clerking in South Carolina, they loved college football, right? And if I was not willing to talk college football with them, I would have had a miserable experience, but I was. And so it was great. We talked about college football and food at lunch almost every day. And so finding that fit is really important. It will give you a better experience.
So I also clerked in the South on a different federal court, and I was also advised that college football was not The Walking Dead, which didn't exist, but college football was an important part of daily conversations. And so I was told that before coming, I would have to decide if I was an Auburn or an Alabama fan. And I said, and what was the judge? And I was told it was Auburn. And let me tell you, I knew a lot about Auburn's football team that year when I showed up in Montgomery. How do you find out these things? I found out by talking to the support staff and the clerks, and they were able to share enough so that I knew Auburn over Alabama, and I knew it was going to be football, not basketball, right? I knew, but the kind of things you're talking about, we sometimes don't know about our own classmates or faculty and staff, but judges are pretty removed. They're these figures, we see them on the bench, they're addressed by formal titles, they're in these formal settings. How do you find out that they like dogs, that they come from Australia, that they like a particular sport? How do you get to know that sort of thing?
So it varies by court. It depends, like every answer in law school. Actually, on the Georgia Supreme Court, you can find out what church several of the justices go to because it's on their profile on the court's website. I was sort of surprised by that. But there are some resources out there for looking at judges. You can look at articles they've written. You can look at interviews they've done. If you're looking to clerk in Georgia, look at some examples. This is actually sent in the book. This will have to be the second edition. Look for the Georgia State Bar Journal, and they probably have interviews from some of the justices, or find a panel they served on and watch that. There are definitely resources out there. I think it behooves law schools to also create a book where individuals who have clerked for judges provide some feedback to the school. Maybe fill out a form and just provide some tips, obviously within the confidentiality that you gain in chambers that you can share with other students. I've had students from Harvard contact me who are applying to my judge and ask me for advice and particular information about him. So it involves you being out there and proactive and doing some work, and then hopefully your school will have resources available as well. But you can actually, it's easier now with social media and judges being more open on social media. I have friends, a friend on the Georgia Appellate Court. He's very active on Twitter, and I could tell you all sorts of things about him just from looking at his Twitter feed. And none of it is controversial. He has feelings about footnotes, and he likes to work out an Orange Theory. But it's still information to know about him that you could bring into an interview.
So speaking of social media, one of the questions that students often have is how much do I put down about myself? I understand fit and alignment, but if I'm an active member of a set of organizations, in either my academic life or in my private life, should I be signaling? Should I be worried about how that will be read? Will, in fact, chambers look at social media to see what they can find out about me? So in that same world where you say you can find out more than you think, maybe even about a brand new judge who's been nominated or confirmed to a court, how do you deal with the flip side of that in a thoughtful and responsible way?
Well, the internet, like diamonds, is forever. And so students, regardless of whether you want to clerk, and you should all want to clerk, please be mindful of what you put on the internet and social media, because it can come back to bite you at various stages in your career. You never know. I spent the early part of my career vetting federal judges, and this was sort of pre-Facebook, Twitter, and all of that. I cannot imagine vetting judges right now in the age of social media. So please be mindful of what you put on your on social media in general. I was telling you a story about when I applied to law firms, and I think this answers the question. I was applying to law firms, just a handful of them, to work my 12th summer, and I was told from the career services office that I was advised that I should wear a skirt suit to these particular interviews. And I had just bought a really nice pantsuit, and I said in my mind, and probably out loud, because that's the kind of person I am, well, if they're not going to hire me because I'm wearing pants, I probably don't want to work there, right? And so this is what I tell students in terms of having things like ACS or Federal Society or other types of groups on their resume. If someone's not going to hire you because that's on your resume and you feel that it's important enough to put on your resume, you probably don't want to work there. And that's, again, protecting in terms of fit, putting you in the spot where you're going to thrive and most benefit the judge and get the most benefit for yourself.
Does fit necessarily require ideological alignment? Say you are part of an organization that has a political valence, a philosophical valence. You've written on a subject that, again, may or may not show your own commitments and interests. So should someone who thinks of themselves as more liberal only be looking for liberal judges? For someone who thinks of themselves as more conservative, only be looking for conservative judges?
It depends. So some judges do prefer to have clerks that are ideologically aligned, and some judges just don't care. Some judges, there was talk that Justice Scalia, for example, would always have an opposition clerk, right, who disagreed with him. But fundamentally, you have to be okay. For example, the 10th Circuit, there's a lot of death penalty litigation. And so if you are avidly opposed to the death penalty, you may not want to clerk for a judge who is pro-death penalty, working in a jurisdiction where those cases are going to come across your desk. So some of it is you have to individually decide that you understand that part of being a clerk is that it's ultimately the judge's name on the opinion. And judges, almost every judge I've met, wants feedback and advice and to hear the perspective of clerks. But when a decision is made, a decision is made. It's much like in the practice of law, when you're working for a partner or a client. Sometimes decisions are made that you may not agree with, and you kind of have to go with that. So I think it's okay to apply to judges that you don't agree with if you're okay with it. And then, of course, the judge is okay with it. I have some judge friends that I wouldn't send students to that are ideologically not aligned, because I know the judge isn't looking for that. But most judges, I think, are open to clerks regardless of ideology.
Yeah, so that's my experience as well. And I think that's an important point, because you can learn a lot so long as you're comfortable with the first point you made and understand it is ultimately the judge's chambers. The learning experience could be as good or better with a judge whose political philosophy may be different from the one that you've developed or are beginning to develop early in your career.
In most cases, everyone loves to talk about the controversial, 5-4 Supreme Court opinions. Most of the cases are not that sexy, in any court, including the federal court. So those big issues do come up, but not at the speed you think they would. I think we handled one really interesting First Amendment case when I was clerking. But criminal matters, again, death penalty matters, those do come up more frequently. And so if you would have an ideological disagreement there, it's important to know.
Part of that is ideological, part of it is understanding what you're comfortable with. I know I clerked in a circuit where there were active death penalty cases. I worked on those cases. The judge I worked for sat down and talked to all the clerks. One was identified as the death clerk. I hated that label. And again, this is a number of years ago, but he would not allow a married clerk, not gender, married, to be the death clerk because you often found yourself up 24 hours and all night long. And he wanted to make sure that if someone had a set of personal obligations that would make that difficult. Whether you agree or disagree, again, it was not gendered, it was a status question. I want to talk about one more time. I want to open the floor to questions, but just one more question, which is another theme in your book, and it seems to describe a changing landscape, is stacking clerkships. And for sort of an earlier generation, that concept was not unknown, but quite real. So we will go to the floor after the answer to this question, so prepare your questions.
All right, so let's say you really want to clerk at the state Supreme Court or a federal district or a federal appellate court, but you don't have as strong of a resume. So stacking clerkships is starting at a lower level clerkship, so maybe a state intermediate appellate court or even a state trial court, and working your way up by doing multiple clerkships. Now you have to be in for the long run, right, to do more than one clerkship, which again, I think would be a wonderful experience. But if you have a partner that may have to move or family obligations, or you just want to make money, that may not be doable. But we've had great luck with stacking in Arizona law. So I'm thinking of two recent grads who are both clerking at the state Supreme Court right now. They will go from the state Supreme Court to different federal trial courts, federal district courts, and then one of them is going to go to a federal court of appeals. And I bet he's going to apply to the US Supreme Court. Or maybe Teresa already knows if he is or isn't. But I've seen students go, so for again, a Tucson example, I've seen students go from our Division II, our Intermediate Court of Appeals, to the federal district court. One of our judges at the federal district court, who I think is a graduate of the school, likes to hire clerks with a couple of years experience. And it's becoming more common. I was telling the dean about this when I was speaking at Lewis and Clark a couple of weeks ago. One of the faculty members, and I started talking about stacking, and he had clerked in the 90s where stacking wasn't common. But increasingly, federal appellate judges want clerks who have a year or two of experience. They don't want clerks right out of law school. They want to see that you've done some work. And I know some of our Ninth Circuit judges are that way. So stacking is a great way to be eligible for a clerkship. It's also these judges who want experience. It's a great way to transition a career. So let's say you go to New York to do transactional work, or go to California and do transactional work, and you decide after a year or two that you hate it, right? You can then use a clerkship to transition your career. And the benefit of that is you're not stuck with the hiring timelines of students, right? You don't have to wait till you graduate and take the bar, because you've already graduated and taken the bar. So you can go at any time. As soon as a judge is appointed and takes office, you can be ready to transition into that clerkship. So there is some advantage. If you think you might want to work a year or two, there's advantage to doing that and then clerking after a year or two of work.
So it's a great point. And then we'll go to audience questions, which is, it's not just first year, second year, third year in the traditional JD program. There's a window. It may not be infinite, though some people who've been out a long time have gone back to clerk, but there's certainly a non-trivial window early in your career where for many judges, that early experience is a plus and may open doors. And I think that's a really great point to make. With that, why don't we take questions from the floor or from the substantial evidence? Here we go. For Sam.
So one is you talked about fit. You talked about potentially during the interview finding out that you don't watch the same television shows. Advice to students, I guess, watch a lot of TV. But what about if it's not a good fit after you receive the interview and then you receive an offer? That's question one. Question two, would you advise a first year who's interested in ultimately clerking to extra?
Oh, let me take the second one first. Yes, I would. But with a caveat. So when I was a 1L, a Ninth Circuit judge came and talked to our Federal Society chapter. And because he was from Oregon and I was from Oregon, they put me at the same table with him. And he offered me an internship on those simple grounds. And I said no, because I really wanted to clerk for him. and he did not hire his interns as clerks. So there are a handful of judges who have a policy of not hiring interns or externs as clerks. So you just need to be aware of that if you're interning or externing for a judge. But otherwise, it's a great way to get to know the court and to know the judges. So yes, I think that's an awesome experience, especially as 1Ls during your 1L summer, because you know so very little about law as 1Ls going into your summer experience. And so you will gain a lot of knowledge during that externship year. The first question, that's a tough one. The first question is, what do you do if you interview with a judge and you get an offer and you realize it's a poor fit? So the goal is to never be in that situation, because you have done so much research and so much advanced work that you are really only applying to judges that you would accept an offer from. And that's including taking into consideration, this judge is in a small town. I was telling the dean, when I interviewed with my judge, at the end of the interview, he and his career clerk and I piled into his minivan and he drove me around town. He said, Tessa, you're coming from Boston to South Carolina, and I want you to be okay with this. And I said, well, Judge, I grew up in rural Southern Oregon, so I'm good. I'm good with however rural you get me. But if you come from a big city, you should be thinking about, do I want to go live in a small town in New Mexico before you apply to those clerkships? But I think if something happens in the interview, and I won't define what that something is, that makes you feel uncomfortable about accepting the clerkship, then you should say no. I strongly recommend that you tell your recommenders that and you talk to your career services office, because in many cases, you could be potentially burning some bridges with the law school by saying no. I'm really careful about personally recommending students. And if I've gone out of my way to personally recommend you to a judge, to call the judge, to text the judge, or whatever we do, Facebook message the judge, if you say no, that reflects poorly on me as well. And so talking to me or talking to your other recommenders and your career service advisors is important to do.
Early, not late.
Early, not late, yes. I would rather hear it from you than from the judge, because I will hear it from the judge.
Well, but also early allows a way of derailing, of saying, I recognize the conflict. It may not be entirely the story, but of saying, I didn't realize how small Columbia was. But if you wait for an offer and decline it, the chance of institutional harm, not just a personal choice, I think goes up. Other questions from the audience?
What advice would you give to both the student and a professor in this situation? So hypothetically, you have a 1L legal writing professor, let's just say. Speaking for a friend. And they have a student in the fall who is flying under the radar. And they don't get to know the student that well as a result. The student doesn't do a lot of outreach to the professor. Time goes by, and in their third year, they reach out, I need a letter of recommendation for clerkship. And does the professor then make an attempt to try to get to know the student at that point to write the letter? Or do you just say to the student, maybe you're better off getting somebody who really knows you well? But I think they want the legal writing professor's recommendation because you can speak to the writing better.
So just to repeat the question, it has to do if you ask later a legal writing professor to serve as a reference, but it's not someone who got to know you well. How should the professor handle that? How should the student be thinking about it? They want the legal writing imprimatur, but a little bit like the famous unnamed professor, the person either might not be able to say much stronger, or just might not be able to say much.
That's tough from the professor standpoint, because we hate turning down students because we know you need these letters, right? We want to write you a good letter, unless you ask me the day before it's due, and then I don't want to write you a letter, and I will probably say no. So please ask with at least 2 weeks notice, if not more. So I think you as a professor have to evaluate, can I really write this student a strong letter? And then have the nice conversation that my professor did with me of saying, look, I went, go back and look at the student's paper. I maybe look at the extensive comments provided and see if something refreshes your brain to write a strong letter. And if not, I think you need to be open with the students. But then students, what does this mean for you? Well, you need to do more than just, get a grade in that unnamed 1L legal writing professor's class. You need to check in with her, let her know what you're doing. We love when students stop by and tell us about their summer plans and ask our advice on law firms. I mean, that's the fun part of our job. So keep in contact with the people that you're going to want to write your letters of recommendation, and be asking their advice as you come up with your list of judges, or as you think of courts that you want to clerk on, because that will ultimately improve your letter. Or take, I know that a lot of our 1L professors don't teach upper year classes, but try to take someone for more than one class. If you really liked one of your 1L professors, have them supervise your student note or take them for a small seminar your second year. And that will give them the ability to write on things that make a good letter. So what are those? Your attention to detail, you're responsive to email, like you answer an email in one day, that's amazing. That's important for judges. You're a self-starter, you're an independent thinker, you're curious. I mean, all these are things that judges want to see in a letter. Simply, me writing a letter as a con law professor that you got an A in con law, tells the judge nothing about your ability to be a productive clerk. Are we running out of time or so?
We are getting to the end. We have time for one more question.
Yes. Yeah, it's very good.
You may not get an answer.
What degree do you recommend students, and to what technology do you think that would be helpful in clerkships? I know that certain clerks are at different levels of their tech savviness, and some will lean on clerks or other staff members to sort of help them along the way or advise them. So what would you advise students with regard to getting familiar with more than just how to use Microsoft Word?
Oh no, word perfect. Word perfect. Knowing how to research, basic research skills, but also knowing who to ask for questions. I remember having a really thorny research issue when I was clerking, and I called Westlaw Help, and they helped me. So, you should have basic research skills, or even more than basic research skills. Let's put it that way. You should know how to work Lexis and Westlaw, but a lot of that is just being intellectually curious, right? Getting on there, testing, search opportunities, knowing that there's probably circuit, in the federal courts, there's circuit librarians who are willing to help. In the state courts, there may also be state librarians who are willing to help. And then knowing at the end, you can call that 1-800 number and they will help you. And that is okay. All part of the learning process.
Or take advanced legal research.
You should. I took advanced legal research. That was a great class.
Everyone, please join me in thanking.
Thank you, everybody on the line.
Stay tuned for our next book talk soon.